Good afternoon. This is the public hearing of November 9, 2023 regarding towing practices in Vermont. My name is Christopher Curtis. I'm the Director of the Consumer Assistance Program at the Office of the Attorney General. We welcome today any and all public comments by those assembled to learn from you your thoughts about towing practices in Vermont. I will begin our testimony today with a recitation of the working group or study commitments as we know them from statute. As a preliminary matter, I will also note that this meeting was publicly warned for more than 2 weeks. In light of the weather and snow and travel conditions, this meeting is being held remote via Teams. The physical location at 110 Cherry Street in Burlington has been noticed, so anybody who might happen to appear there will have the call-in information or the login information by Teams, which was also posted to our website and posted at the site. If there are Vermonters who need some kind of accommodation and would like to testify in person, I am open to holding a second public hearing in person at a later date. But for purposes of today, I wanted to respect your time and not have to reset a meeting. So with that, let me just share with you all the language from Act 41. It is an act relating to miscellaneous changes to laws relating to vehicles, and it requires the Attorney General to study motor vehicle towing practices. Specifically, it requires as follows. The Office of the Attorney General shall study motor vehicle towing practices, including practices related to abandonment or suspected abandonment of motor vehicles, such as the use of liens and bonds to ensure the recoupment of costs borne by towing companies, storage practices, and pricing. In conducting the study, the Office of the Attorney General shall consult with the Department of Financial Regulation, the Department of Motor Vehicles, the Department of Public Safety, the Office of Professional Regulation, and the Office of the Vermont State Treasurer, and solicit input and public comment from interested persons and hold at least one public hearing. The study shall at a minimum address pricing of pleasure car and commercial vehicle towing and recovery, including from state and town highways that are restricted based on motor vehicle size, crash site remediation, including costs borne by towing companies, storage practices, including pricing, vehicle access for removal of personal belongings, and vehicle access for removal of cargo, practices relating to abandonment or suspected abandonment when necessary or appropriate, best practices from other states, including a comprehensive survey of the following from other states with a focus on states neighboring Vermont, motor vehicle lien laws, laws related to access to towed motor vehicles for purposes of removal of personal belongings and cargo, and laws related to pricing, including for towing and recovery, remediation, and storage. The use of statutory liens when a motor vehicle has been towed at the request of the owner or the motor vehicle has been abandoned as defined in 23 VSA 2151 in order to secure payment of a towing business's towing and recovery, storage, and remediation charges. The retention of the motor vehicle and the contents of the motor vehicle until a towing business's towing and recovery, storage, and remediation charges have been paid. Pause for a moment and let this person in. The use of a surety bond in lieu of the payment of a towing business's towing and recovery, storage, and remediation charges in order to secure the release of a motor vehicle that is being retained until a towing business's towing and recovery, storage, and remediation charges have been paid. Any applicable recommendations for amendments to state statute, and any information that the Office of the Attorney General deems pertinent to the study. The Attorney General shall file a written report on the study, including any recommendations it deems appropriate, with the House Committees on Commerce and Economic Development, on Government Operations and Military Affairs, and on Transportation, and the Senate Committees on Economic Development, Housing and General Affairs, on Finance, on Government Operations, and on Transportation on or before December 15, 2023. The recommendations in the written report shall balance consumer protections and the needs of towing businesses, reflecting the necessary role towing businesses serve in maintaining the health, safety, and welfare of Vermonters. That information is also available at the Attorney General's website, and I encourage viewers to refer to that as well. So, a reminder before we get into testimony from those assembled, if you are not speaking, I would simply ask that you make sure that your speaker is on mute so that we're not picking up any other noise or sounds that may come through. I will also put myself on mute during testimony. And with that, I am prepared to open up the public hearing to comments or questions. Are there questions before we get rolling? And I see Mr. Delia, do you have a question, or would you like to begin with comments?
I'm ready to testify, Chris.
Very good. With that, you are the first one to raise your hand, and happy to have you go. And then I see Mr. Smith has also raised his hand. So yes, just use that function to let me know that you'd like to testify. At the conclusion of your testimony, you can drop that virtual hand so that we know you've concluded your remarks. And Mr. Delia, take it away. If you could introduce yourself and the name of your organization, that would be helpful.
For the record, Chris Delia, President, Vermont Bankers Association. Thank you for the opportunity to join you today in doing this remotely. You were at a long list of issues that you're responsible for in the report. Our focus is solely on the lien aspect of your report, and we will follow up our testimony with written comments, but at least wanted to get them into your record today. So to be clear, we have no objections to towing companies being compensated for the work that they're doing out in the field, as well as the storage of vehicles that they may have on their site. The issue for us, as we saw it in the proposed statute, was the potential of a lien priority in front of an existing lien that might exist on a motor vehicle, whether it's a personal transportation or even business-related transportation. We testified before the committee and want to just share with you today briefly that we would object to a tower's lien being placed in front of a lien that a lender has on a vehicle that is already out there. Again, we understand they need to be compensated, but we can't have a tower's lien jump in front of or take a priority position in front of a lien that a lender may have out there already today. We know in the abandoned statute, motor vehicle statutes, that there is reference to notification to a lien holder that towing charges may exist under the abandoned statutes, and maybe that's an option here. It would allow a lien holder to step in and make a determination as to whether they want to cure those towing charges or storage charges early on before they accumulate too much, and then they could take possession of their collateral, if you will. So some form of communication between the towing companies and the lender would possibly be an appropriate outcome in these discussions. But at the very least, we want to be on record saying that a towing lien cannot be placed in front of a lender's lien on automobiles or, again, business-related vehicles. And I'll stop there.
Thank you for your testimony, and I'll look forward to receiving a more fulsome description of your concerns and positions in writing. Mr. Smith, I see your hand up.
Thanks, Mr. Curtis, and thank you folks for having the hearing online today. I would know Dave Malloy from Bellavance Trucking is on my board of directors. He and I both testified before the House transportation committees regarding this matter. And a first question, I guess the question for you folks is
Excuse me,
the
Mr.
testimony-
Smith, before you continue, I'm sorry to interrupt, but can you just state your, the organization who you are representing today?
I apologize. I'm the lobbyist for the Vermont Truck and Bus Association. And
Thank you.
Thank you for the
Please
question.
continue.
So the first question I had for you, was the testimony and exhibits from House Transportation currently in the record, or do we need to officially place them in the record and forward them to your office?
It's a great question. I have taken what I saw posted on the legislature's website and placed those for review to the public on the Attorney General's website dedicated to this issue. However, if there are any inadvertent omissions or if there are other documents that relate to previous submissions, I would encourage you to send those to me. We are happy to post those, and for other listeners or observers, any material sent to us on this topic that is sent in writing will be posted to that website for public review.
Thank you, Mr. Curtis. I'll double check the AG's website to see if it's there. If it's not, I will forward it. And that will also include if I may, the testimony of Dave Malloy and myself in that, and the exhibits that went with it. So the key issue for Truck and Bus Association members is the unknown, the rate variations that can exist for a towing job of a heavy truck. And we understand, there's remediation issues. There's depends on the cargo you have. There could be a lot of personnel needed to reload a different truck. That could be very complicated matters. But we've seen variations in rates which are presented to our members for payment, which are simply there because there's no guidance over this whatsoever. So it is a concern when you have these towing charges on a trucking company, because these are much bigger than a car tow. Maybe it goes without saying, but you can easily see a $15,000, $20,000 charge for towing, remediation, recovery of a heavy truck and its cargo. So the rate variations and the potential in other states to do what other states do, which is have rate schedules posted and managed by the state, whether it's the state law enforcement or state motor vehicles department. It depends on the state. Some states around. So I forwarded those to Mr. Curtis already, what we've seen in neighboring states. So there's rates is one issue. The other issue is this lien on the vehicle and on the cargo of it. I mean, number one issue for us, number one concern for Truck and Bus Association is a potential of having a lien on cargo, because by definition of what my members do, they're hauling someone else's property. And that property needs to get to its destination regardless if there's an accident or not. And it's hard enough to have my members, if there is an accident, take another truck, go get it, and continue on with it. But if it's being held up before payment of a towing bill that is not based on any kind of rate schedule or anticipation of it, what my members have experienced is in some limited situations where they feel like they've been taken advantage of by the towing company. The good news is most of our towers are good, hardworking folks that have longstanding business relationships with my members, that their bills we're happy to pay because that gets our cargo to our customer. And so the number one issue for us is, again, just to close on that, is that the lien on the cargo that was discussed as a potential matter for us is a non-starter. And also in regard to the banking issue of the lien on the truck and trailer itself, jumping in front of my members' lenders seemed inappropriate and probably very difficult to fashion. So the idea of a lien in this is our number one issue, and then the rate schedule is the number two issue. David, I just would ask if David might have anything to add to that. or a different take on it. And I'll close out my discussion now. Thank you.
Before you conclude and we transition to Mr. Malloy, Mr. Smith, you noted the rate schedules that other states have deployed. Do you or does your association have a preferred rate schedule? Or is there another jurisdiction that appears to be particularly reasonable to you or your members?
Well, what I've seen is the Massachusetts scheduling and the way that they handle it seems to be a strong candidate. I'd also like to hear from Dave on that, since he's the guy who handles these types of claims for our largest in-state trucking company. So I would defer to Dave on any preference.
Thank you. All right. And with that, Mr. Malloy, you want to introduce yourself and your organization, please, for the record?
David Malloy with Bellavance Trucking, Director of Safety, and also on the board for Vermont Truck and Bus. Just to back up on the two different issues, obviously one's the lien. We don't own the materials or the products that we are hauling. And with all the laws that are out there right now, the federal laws regarding food safety and everything, any type of delay, a suspected delay, contamination, any of those things, a shipper can reject the load. And there isn't an insurance company out there that'll pay for the cargo because of a delay. And when I mean a delay, say, example, one of our vehicles need to be towed and it had a refrigerated trailer with it, and it gets put in a yard and it's basically impounded. But if people aren't monitoring the temperature, your whole load, if it's off by 2 or 3 degrees, can spoil. And so it's very important for us not to lose control of the product that's in there. And food is probably the biggest one with us. Everything else that we haul could afford a delay. However, some of the equipment that's on our vehicles goes to power companies, comes out of Colchester, very expensive stuff that they can't afford a delay. So for somebody to say, listen, until you pay a bill, you can't have your cargo, it's really, it's not right, to be honest with you, especially coming from our company that we pay our bills on time, every time. So, from a company like ours, that is just a real unfortunate thing to see in any type of legislation. But another big issue is, like what Bill was talking about, was the rates. In that first, I think it was S99 bill, it said reasonable rates. Well, one of the examples that I used, and you'll see that in the documentation, Mr. Curtis, that Bill is going to be sending over, is we had a rollover on 105. The first bill that we received was $88,000 to unload the trailer, write it, and have basically hauled away. But $88,000 for the job that was done was ludicrous. So somehow the banking and insurance got involved, because they're charging an insurance company, an out-of-state insurance company, for this. The same people revised their bill down to $27,668.10. They reduced their bill $61,000. So they sent what they thought at first was a reasonable bill. Then they backed it up, dropping $61,000 off of it, and sent us another one, what they thought was reasonable, for $27,668. So who is regulating what's reasonable? Unfortunately, we had another rollover in the exact same spot a couple of years later. Same scenario. The trailer had to be unloaded, then righted and reloaded. We obviously chose a different company. Their total bill was less than $6,000 for the same job. and that was reasonable to that company. So what is reasonable? And that's where I think we need some type of legislation to say, this is what it is. Now, we use a company currently out of Burlington, a reputable towing company, and we use them for a lot of our work now because they give you a flat rate of this is how much it is per hour, and it's all by the hour. There's not a lot of accessorial charges and random charges that, come out of the air. We saw an uptick in bad billing practices, I would say in the last 10 years. And what's happened is there's companies out there, specifically one, I have a friend that's actually a tower, and but he went to a class, it's called Recovery Billing Unlimited. They have seminars on how to bill insurance companies and to get these bills approved. And basically it's just gouging the heck out of people. So what I would like to see is, kind of on the model what Massachusetts does, find out what is reasonable. Everybody knows what their cost to serve is, or most companies do anyway. I can tell you what it costs us to run per mile. And if we build in, you're building your budget and everything else, what you need to make money. And that's where I think people need to base it on, is like, okay, what's reasonable? The towing people need to be paid for what they do. They need to be able to respond, and they need to have good equipment. All that costs money, and we well understand that because we put our money back into our fleet and we run quality equipment. But of course, that drives our cost up. So we're not always the lowest cost provider. We never intend to be the lowest cost provider. But bottom line is, we can tell a customer what it's going to cost them, for a certain lane or a certain run. And if a guideline was put in that, okay, if you're sending 2 people, this is what it is per hour. You're sending 2 vehicles or whatever the case may be. So to have a rate chart, a rate schedule that this is what is acceptable in Vermont would be a really good way, I think, to do business, because then people know. And the unfortunate part is that right now with the state police, their job is to clean a roadway when a crash occurs. So they don't have time to go back and forth with a customer, like say, get a hold of Dave Malloy because they got a Bellavance truck off. The state police do not have time for that. They need to get that highway cleared. So they need to be able to go down through the list, and if a certain, that whoever's next on the list to be called, if they can't make it, they go to the next one. But the cost should be the same all the way down through that list, not depending on the company that's there. So, and that's what I think has to be fair. If you're going to be a towing company on the state police list, this is the rate schedule you need to follow. And then, for other tows that somebody's calling them directly, let them work it out with the customers. But when you're on a state highway, I think it should be a certain, charge that they cannot exceed per hour. Now, different rate bills are going to be whatever the crash is, because it's going to take more time. Sometimes you can just, pull them out of where they're at and off they go. Other times you have to unload and bring in a rotator crane and stuff like that. But again, that would be all by the hour. If it costs you 8 hours to clean up the site, that's what your charge is going to be, not some fictitious number that you think an insurance company will pay. And that's kind of where I come from.
Thank you, Mr. Malloy. I see we have Mr. Musgrave has his hand up next.
Hi, thank you. My name is Matt Musgrave. I'm the Deputy Executive Vice President here at the Associated General Contractors of Vermont. I appreciate the opportunity to come in and talk. I did submit 2 documents earlier on. One was a written document that I produced, and another document was a document that I found on a state-by-state analysis by the Public Interest Research Group related to towing companies' laws and requirements. And, the thing that strikes me is that, like many industries in Vermont, there is not a lot of regulation. And when you look at the comparison state by state, we're one of the few states in the union that do not have, with the exception of one or two small bullets in terms of abandoned cars, there is really no regulation for the towing industry. As some of the other witnesses have stated, there is no rate schedule. There is no requirement of minimum level of insurance. There is no standard of care. There is no ability to have a towing company that misbehaves or conducts fraudulent activities debarred from being able to operate in the state. None of this exists right now. So when we start talking about adding an additional lien to third-party equipment, that concerns us greatly here at the Associated General Contractors, because our members are generally going to be we are the ones getting carried around on the back of Bell Avance's trucks, our excavators, construction equipment, materials that we need to complete work. And oftentimes the work that we're doing is for state or federal projects. And as we saw last summer, some of those state and federal projects are dealing with challenges from climate change, like the flood that we had to mobilize all of our equipment to get out. And this was a health and safety push to get the roads open, to make sure people's homes weren't being flooded out. So the thought that that equipment would be delayed on the way to one of those safety and health projects for sure is a major concern to us. Another major concern is liquidated damages. If there was a situation where a piece, let's say $1 million excavator sitting on the back of one of David's trucks was held up for a period of time and wasn't able, there was a pricing dispute or a lien added to it because of another problem that was there, and that couldn't make it to the project to complete the work, the contractor might not complete the entire project on time, and the liquidated damages can sometimes be in excess of any of the numbers that I've heard, whether it's $20,000 or $80,000 on the call today. So it's hugely concerning, and it's a hard no for us on a secondary lien of our equipment. I think what strikes me is that this is this process that we're dealing with here was initiated by industry, the towing industry, to try to create ways and methods for them to get paid. And we certainly agree that people should be paid for their work. They should be paid a reasonable rate. There should be predictability in how you're going to work. Things like written contracts and such between the tower and the towee make sense to us. But as a third party, that's not a relationship that we're going to join. I have no control over who David calls to tow his vehicles if they get into trouble or have a breakdown. So as the cargo per se, my only recourse would be against the towing company if there was a dispute between the towing company and between the truck hauling. So we want to avoid that challenge. And then, you know, when we really think about it, this does seem like the industry is asking for more authority to deal with the public and to deal with private businesses. So in return for that, I think what we are hearing is maybe an industry that's suggesting that they would like to be regulated. I think, you know, when you look at consumer-facing and business-facing businesses, I mean, just simply look back 2-3 years ago, we created a registry database for home builders to deal with fraud that exists in that market. Some of the important parts of that law that was put together was that it did have a process for them to get registered within the system. They have to answer those questions that are extremely important for people that are dealing with the public directly. Are you paying your taxes? Are you a felon? Have you paid all of your child support? These are things that licensed people are required to answer in order to get registered or get licensed in the system. It's a way of affirming their ability to deal with the public, because as you may imagine, bumping into somebody out on Route 15 in the middle of nowhere in the middle of the night, it's a situation where you have a vulnerable person that's dealing with a business, and that business should have a layer of regulation on them. So we would urge, number one, we're fully opposed to any third-party liens that we place on our equipment or any personal property that's in there. And if there was to be more consideration moving forward, we could support a rate schedule. We could support requirements like minimum levels of insurance. We could support a standard of care. We could support the ability to disbar people from the state of Vermont to be able to do that. And then there is a process, and whether it's the Office of Professional Regulation, Department of Transportation, or another entity that would regulate those towing companies, we could see to adding more authority to that industry. And it does sound like they're asking for it. It does sound like they're asking for some regulation, and we believe that includes registration or licensure.
Thank you, Mr. Musgrave. Mr. Musgrave, can I ask you a quick clarifying question?
Yep.
So with respect to third-party materials, whether it's goods and services that are being shipped or whether it's machinery and equipment, is the issue there that once the towing vehicle is sort of removed from a road or there's an accident or something like that and it's taken to a lot and then a dispute arises as to the costs of the tow, is the issue that the industry would like the original vehicle to be able to continue to transport, or is industry saying, oh, if there's damage to the vehicle and it's going to require repairs or it's being held up, we can send another vehicle to go and pick up the material, the equipment, the supplies, or the shipment, and that can leave and get to where it needs to go? Or is it that, no, we want that original vehicle that's been towed and is the subject of the tow that was hauling the freight, we want that to be released? Because I could see that there's, potential tension between the tower and the vehicle that's been towed versus whatever's on the flatbed or that's en route.
Right.
So I'm just trying to get a little clarity on that, if you can, for me.
No problem. Yeah. So in most circumstances, I've been with the Associated General Contractors now for 5 years, and thankfully, we don't see a lot of accidents that occur. It's going to more likely be a vehicle breakdown from the vehicle hauling our equipment. And in most cases, what would happen if it's Bellavance or another reputable trucking company, they're going to have spares that they'll send out, pick up our piece of equipment and get it out to the site so they're able to do their work. So that's really the concern, is that we have the ability to continue to move our equipment. Obviously, if it's destroyed and it's on the side of the road, that's not a possibility. But if it's broken down trailer and it could be hauled with another piece of equipment, that should be released. And the concern that I have on the third party, the contents of a vehicle, and I think if you look at the original legislation that had passed, or the bill that as it had passed out of the Senate Committee on Transportation, ultimately the Senate, they had already considered the fact that there may be an attraction to whatever is in the vehicle. And in fact, they produced a list for us. In the House side, they said, well, we won't keep school books. We won't keep health and safety supplies. We won't keep this. So they've already acknowledged the fact that it does depend on what's in there. And I would say, if it was an empty flatbed truck, you're more likely going to see the $20,000 estimate. If they saw $1 million piece of equipment in the back of it, or a bag of diamonds, you're probably going to be looking at a little bit more expensive of a tow. And again, I'm not shaming the industry, because I think most of the players in the industry that I've dealt with have been stand-up businesses, have done great things. I grew up and went to school and managed a restaurant in downtown Burlington, and I can assure you that they are not all the same. So there needs to be some level of regulation.
Is there a question of economic waste in the sense of the third party was simply paying for a service to get from their products from point A to point B? They're really not involved with whatever may have intervening factors of a breakdown or an accident or whatever else. And similarly, for the average consumer who may have left a handbag or a wallet or their driver's license or their medication in a personal vehicle, there's a question around access, right? Once the vehicle's been impounded, can they get access to that vehicle? And in some ways, it feels like there's a bit of a corollary here. Different magnitudes of size and order, certainly. But is that sort of what you're suggesting? Is that access to the goods or the equipment that from your perspective is problematic?
Yes, I think it's the challenge is that we did not have, as cargo per se, we don't have a contract or an agreement or any ability to shop for a tow company. That contract exists between the hauler and the towing agency. So the fact that my piece of equipment or bag of dime, whatever you want to call it, is a part of that. I need to be able to get my piece of equipment out, especially when you're talking about construction equipment. Again, that I think Chris Delia may have a few loans out there on our equipment. Most of this equipment that we're operating is bought either by loan or it's a lease. So you have a third party involved already. So it's the concern about our ability to get back our personal property or business property.
Mr. Malloy, you've been waiting patiently with your hand up, so I want to acknowledge you.
Yeah, I just wanted to back up Mr. Musgrave. It really is access to the cargo to keep it moving. Because again, we don't own what's on the trailers.
Thank you.
Yep.
And I'm looking to see if there are others at this point who would like to weigh in with their thoughts, views, comments, perspectives. Again, we are doing this voluntarily, so if you want to raise your hand and chime in, I see Mr. West would like to share his thoughts. Please go ahead and make sure you introduce your organization that you represent, please.
Thanks, Christopher. I'm Rod West from Black Fork Towing in Richmond. I am a light duty tower servicing retail and law enforcement markets. While it's not directly in the charge here, my concern is with how insurance companies treat towing claims in Vermont, and specifically liability claims. We are left to be the janitors of the roadway for the state police, and we do that happily, but there are many jobs that towing companies don't get paid for. There are some instances with out-of-state towers, heavy-duty towers, just to get back to David and Matt, where the only thing valuable in the combination is a cargo, where you have an old tractor and an old trailer, and it's common for insurance companies to abandon or say, we're not going to pay on that. And so you're putting the heavy-duty towers in a funny situation if you don't allow the cargo to be part of it. So generally speaking, towing companies, heavy duty towing companies, try to bundle their claims all together and say, somebody pay me, and then I'll let everything go. In my situation, I'm just working the last couple of years on 4 different lawsuits of vehicles that didn't have collision coverage. They were involved in major collisions, major cleanups on the interstate. And the insurance companies refuse to pay based on the liability coverage that they have, which includes property damage coverage and remediation thereof, typically speaking. I can sue the operator, and sooner or later, the insurance company pays up, but I wind up being upside down on legal fees to do that. I mean, I have some expensive tow bills when I use a crane to recover a car that's, been shattered and behind the guardrail. But in many instances, that's just not practical for me to pursue a lawsuit. In most instances. State of Massachusetts has a law that if an insurance company works in bad faith, that they have to pay double, they must pay at least double and can be assessed triple damages. So that holds the insurance companies accountable in the state of Massachusetts for following the laws. In my case, they just say no, wait till I sue, then they pay up, and I'm still not ahead of the game. My perspective is from light duty work. I have friends in sympathy with the people doing heavy duty work. I'm curious about lien position and where a mechanic's lien falls versus a proposed towing lien in terms of position between a first lien, a bank lien, and so how that would all come together in the end. But specifically, I'm looking for the legislature and or the Attorney General's office to give towers some support to state that insurance companies need to pay up without being sued and or make some incentive for them to do that so we're not stuck. And we get stuck a lot. I like working for state police, but you know, a quarter of the work we do is unpaid, whether it's abandoned vehicles or low value tows that people only have liability insurance. And I will submit written testimony later. Thank you.
Thank you, Mr. West. Quick point of clarification, is the quarter of the work that is unpaid, is that your personal experience, or is that an industry standard, or where does that number come from?
Oh, most towers would quote it more like a third, but it's anecdotal. I don't have specific figures for that.
Understood. I just wanted to see if there was a source. So, thank you. I am just admitting a couple of other folks to the meeting that have just joined us. Others who would like to comment, share their thoughts, or otherwise reflect on either the legislature's initiative or this working group study process.
I'm not sure how to raise your hand on a phone, but.
Very good. Well, I don't see any other raised hands, so if you'd like to state your name and if you do represent an organization, feel free to share that, or if you're just acting in your personal capacity, that's fine too.
No, Robert Momini, I'm the president of the Vermont Towing Association. Just listening to the testimony, you know, everybody has good and valid points, but you know, what towers are looking for is some sort of fallback that we can have, like Rod from Black Fork Towing was saying. You know, towers are essentially the cleanup crew for the roadways, and most reputable trucking companies like Bellavance and any of the most Vermonters have insurance, have a way of taking care of their accidents. But what we see up here is a lot of carriers that are from out of state that don't have insurance. So a tower could essentially incur tens of thousands of dollars in fees to clean up the roadways and then not get reimbursed for their services. Same thing with the car world, you know, with light duty car stuff, same situation. You know, you could have a car that's been rolled down an embankment into a river or any sort of situation that the tower has incurred costs to clean up that situation without a means of payment. So I think the lien portion of this gives us some sort of access to have anything that may, you know, if the car is worth anything, we can recoup some of our costs to this. We had introduced a surety bond in lieu of that. So in the remarks of the general contractors, you know, with their equipment, if they're in an accident, they need their equipment, they can, most tow companies are going to release it. And if you issue a surety bond, which costs you pennies on the dollar and can be done within an hour, that ensures the tower is going to get paid for the amount that they're they're owed, and they can have their equipment back. So we're trying to give some sort of protection to the truckers, to the contractors, even to the general public. You know, a surety bond on a car is, you know, next to nothing if it's a matter of waiting for funds to be transferred. I believe the Bankers Association, they like the mass rates. I don't know if you've looked at the mass lien law. So if we're going to adopt rates, are we adopting lien laws as well? The New Hampshire police rotation just this year introduced some regulation. They can't regulate individual tow companies. Each tow company's expenses are higher or lower than the next guy. You know, we don't know what their overhead is for their business. However, the rates, their posted rates, what they charge, have to be submitted to state police in order to be on the rotation. Therefore, if there is a complaint by a consumer or trucker, the state police can open the rate fee and say, these were your posted rates that you sent us. Obviously, if they find them exorbitant, they can address that at that time. I believe it was, I've got lost here, but general contractors, they were saying there's no reprimanding for, on the tow rotation list. And there actually is. Vermont State Police have a form that needs to be filled out and abided. And at the bottom of it, it talks about, there's a whole section labeled here, removal from rotation list. And it's up to the station commander to remove from the list for overcharging, utilizing unsafe and incompetent operators. It talks about operators' ability to perform satisfactory service, response times. So it is spelled out but I don't believe it's a law. I believe it is a state police policy within their rotation. So these are just some things. We're not, you know, like any industry, there are, I'm sure, some bad towers that do things they shouldn't do. Absolutely, but that goes with any industry. And we're, you know, we represent 58 towers throughout the state of Vermont. You know, we just want to be paid for our service and at a fair wage. And yeah, I guess that's all I got.
Thank you for your testimony. So just to circle back on that, Mr. Monami, so theoretically, is there an opposition or an objection to clear and conspicuous rates that are disclosed to consumers and businesses that reflect the true and accurate costs of the towing business, whether that be hourly, whether it be flat? You know, I'm agnostic. I'm just trying to get clarity. We've heard some testimony today that suggests that more clarity and certainty around rates would be a benefit, and I want to understand from your perspective whether that whether you believe that's also true.
I believe that, you know, regulating rates in some areas works. In Vermont, you know, there are, I think, 6 or 7 rotator trucks in the state of Vermont. You know, if you took Florida, for example, there's probably 500 of those trucks. So but their call volume is, you know, they could get 2 or 3 truck rollovers a day for one company, whereas in Vermont, you know, we may have one or 2 a month. So is regulation, you know, I don't think anybody would have a problem with regulating towers as far as providing insurance. To be on the state police list, you have to provide them your insurance and your policy limits. You know, I don't think anybody's objecting to that. I don't know that a set rate for the entire state of Vermont is going to work, especially Northeast Kingdom take. You know, you can have a tower in Newport, Vermont that gets a call from state police in Canaan, Vermont, which is, you know, an hour and a half drive. So whereas compared to somebody in Burlington, you know, they're 3 miles from where the call is. So a set rate is not gonna work.
But isn't that part of wouldn't that be part of the function of an hourly rate that's established? The longer distance is factored into the time.
So most companies, I mean, if we were to provide the state police with our posted rate, so if there ever was a question, you know, you stated in your rate form that I charge $3.50 a mile. Okay, well, it was 60 miles. So did he overcharge? You know, did he charge $5 a mile when he told us he was only going to charge $3.50? So that, I mean, that could be, you know, a posted rate for that individual company. But, you know, my rate could be $3 and yours could be $5 based on, you know, your expenses of your truck. You know, are you running a brand new truck? Are you running an old truck? Do you have the same insurance policy? You know, insurance rates have gone through the roof for towers. These are all things that factor into our set operating costs. Plus, we're all in business to make money. Now, do I think, you know, one, like he was saying, a load of diamonds, you know, your bill's going to be higher? No, that is not how it should be. I mean, it should be based on the efforts that and equipment that took to do that job, not what the load is.
Thank you. Okay, I see some other hands up. I'm gonna, Mr. Malloy, I think your hand was up first, but you've already.
Yeah, I do have.
And then I'll turn back to you. I would just note, I do hope to avoid, I don't want to get into a, this is a public hearing, so we want to invite comments from all of the participants of your relative positions. If there are positions of statement with which you don't necessarily agree, you know, this may not be the best forum to get into a sort of a debate or a back and forth on particular points. I would rather that folks allow everyone the space to make whatever comment they would like to make. And then in your written follow-up, if you want to raise particular points of opposition or note differences of opinion, that's a really excellent way to do that. So we do have time, and I'm not seeing a ton of other hands go up for new discussion points. So I would just ask that everyone be respectful and polite and try to refrain as much as possible from debate. This is an open forum, and I really want to encourage everyone to, I'm appreciating hearing different views on these topics. And I appreciate that, and I can hold that there are different views on these topics. And so we're probably not going to convince anyone of our particular position today. And so just limit your statements or positions to facts, and happy to hear more offline or in written testimony follow-up. So just a friendly reminder on that point. And with that, Mr. Musgrave, did you have something you want to add? And then Mr. Malloy, you'll be next.
Yeah, just two quick things. One was, and this is, I understand the purpose of the public forum, so I just wanted to make a point of order that I did not, in fact, talk about the police disbarment list when I was talking about somebody being disbarred. I meant in general, if someone was to break a state law or act unethically or commit fraud, my suggestion was a disbarment from operating in Vermont for anybody, whether it was the state police, a private call, abandoned vehicle. So I just wanted to make that point there. And then what I'm hearing is that I think the conversation has turned a little bit to the different ways that people are operating their businesses. And I think that it's important to note that, you know, I get it. Buying a $750,000 tow truck is a huge business risk, but so is buying the $1 million excavator, and so is buying a pizza oven, and so is getting your law license. You take risks, and that's what running a business is all about. So thank you.
Thank you for that. Mr. Malloy?
Yeah, I just had a couple things. Unfortunately, the president of the Towing Association says that there's truckers coming in with no insurance. Well, to have a DOT number, you are required to have $750,000 worth of coverage. And so I'm not sure, you know, how somebody can be operating with zero insurance. Now, the type of insurance that they're buying or the companies that they bought the insurance with, unfortunately, like Ron has already stated, is that he has to sue an insurance company to get paid. Well, maybe that I would support, you know, putting laws in if insurance company isn't paying the record bill, that they'd be penalized for it, because you know, we've asked them to come out in the most inclement weather and everything else and put themselves at risk. They need to get paid. I agree with that 100%. But in order for any of that to be active accurately, I think that a rate table per hour would have to do it. Now, you know, to set up a rate table per hour, the example going to Canaan, if you're leaving Burlington and going to Canaan, it's going to take you 2.5 hours. If that's the closest rotator record that needs to take care of this, that's what the bill is going to be. You know, that's where the equipment is. So again, it's going to be justified because there'll be a rate schedule out there. If you're sending a rotator, it's X amount per hour. If you're, you know, 3 hours away, you've got 6 hours worth of travel time because you got to get the thing back here too. People understand that, and then it's justifiable. But just to have a random number, no, I don't agree with that. And then this, the bond that he's talking about is pennies on a dollar, perhaps. I don't know. But here's where the real problem is. The try to get a bond after 5 o'clock on a weekend or a holiday. How are you going to do it? And unfortunately, trucks don't break down and they don't crash just 9 to 5 or 8 to 5. So most times they crash, the state police are out on the road midnight, 1 o'clock. You know, that's when this stuff happens. That's when the weather happens. That's when the state isn't, you know, on the state trucks aren't out as much at that time because that's when the public is out there the least. So everybody's controlling costs. You're not going to get a bond after 5 o'clock. You're not going to get them on weekends or on holidays. Thank you.
Okay, thank you for that. And are there others who have not yet had an opportunity to speak who would like to share their perspective? Mr. Bergeron.
Thank you, Chris. I don't want to belabor the discussion, but just to officially go on the record, and Joe Bergeron, by the way, President Association of Vermont Credit Unions. And as has been mentioned earlier, from a credit union perspective, any concerns that we have with the bill that was in the legislature in the last session and your research project here, any concerns that we have are limited primarily to the lien issue that's already been discussed by a number of people. But a couple sidebar parts that kind of go along with that is that not all the time, but sometimes I've heard concerns from credit unions as lenders about timely communications between entities that are towing vehicles and the lender notifying them that, you know, it's in their possession and they've towed it, and the timely release of collateral that a lender may have a lien on when it makes compensation to whoever the storage company is or the towing company. Some stories I've heard from some credit unions as lenders, you know, have reflected that it's not always done in a timely manner. Sometimes it drags on and whatnot. But like others have cited, you know, it takes all kinds, right? Some are very responsive, others are not. Maybe it's reflective a little bit of the lack of, as somebody else referenced, the lack of regulatory structure around that industry. That's not really our concern in terms of, you know, how a particular industry that's not ours is regulated. But I just did want to go on the record citing those two things. You know, credit unions are, and also another thing, you know, although there's some commercial vehicle lending by credit unions, the vast majority of what's on a credit union's balance sheet, what's in its loan portfolio, is on consumer vehicles that are either being repossessed or have been abandoned or whatever else. So we're not talking about the kinds of situations that many of your participants today are focused on with the contents of large commercial vehicles and things of that nature. And so the dollar amount of issues are probably on a much smaller scale. Not probably, they are on a much smaller scale on a per vehicle basis. But if you look at it from a lender perspective, and you're talking about hundreds of those or thousands or tens of thousands of those since we do, a very large percentage of the consumer lending on new and used vehicles, whether they be cars or RVs or motorhomes or whatever else in the state of Vermont. It adds up quickly and, is a daily occurrence for us. So just wanted to go on the record that we certainly will provide written comments that go into more detail, but thank you for having this hearing and letting us all share.
Thank you, Mr. Bergeron. I'll just note that we are about an hour into this public meeting, and we've heard from several that have made their views known. We have a number of participants listening in. I know that there are several representatives from various state agencies, and if any of those agency staff would like to comment, certainly welcome your perspectives. On the other hand, I know that this is largely to hear from the public and from industry. I will also note, if anybody has a particular thought or perspective on the individual consumers with personal vehicles and towing, I know that is the subject of some discussion in the legislature. I know it has come up over the years, and I certainly would like to invite perspectives on that as well. I think most of our discussion today has been talking about the larger commercial carriers and what happens in the event of a tow where there's other goods or equipment at issue. So I am mindful that consumers have a say in this topic as well, and there are a lot of perspectives and on that, both from the towing community and from those individual Vermonters as well. I see Emily Kosicki's hand is up.
Sure. Just introducing myself. I'm Emily Kosicki. I'm Director of Policy from the Department of Financial Regulation. We're one of the consulting entities on this report and really appreciated hearing all the comments today, in particular those related to insurance issues, and then certainly the lien issue as well. But just wanted to, say if there's any follow-up in terms of concerns you're having or trouble with insurance companies, you can always contact the DFR, and our insurance division has a consumer services program where they can assist with issues. So if there's anything you want to submit to the AG's office as part of this study specific to, those examples of insurance coverage issues, we'd be really interested to learn more about that.
Thank you for that, Emily. And so while we're on that topic, maybe what I could do is, in the absence of substantive comments, procedurally, I'd like to just invite state agency staff to introduce themselves by name and the agency that they represent. And so for others that simply review this recording later on, they will know who the particular stakeholders are. So do we have volunteers to at least cover that part of the hearing? Yes, Mr. Boyles.
Hi, everyone. Gavin Boyles, Deputy Treasurer from the Vermont Treasurer's Office. We, like DFR, are one of the consulting entities on this. And I wanted to thank everyone for their comments. And it's very interesting to hear. It's an area that we in the Treasurer's Office don't often get to delve into. So it's all very interesting. Thank you.
Thank you, Mr. Boyles. Mr. Smith, I see your hand up.
Michael Smith, I'm Deputy Commissioner from the Department of Motor Vehicles. We too are part of this report, and I follow along with Gavin and appreciate everybody's input. Thank you.
And Ms. Hibbert.
Hi, my name is Lauren Hibbert. I'm the Deputy Secretary of State, again, a collaborating partner, and I appreciate hearing everybody's information and feedback on this issue.
Thank you. And Mr. Farmer.
Good afternoon. Roger Farmer. I'm the captain, troop commander for the southern half of the state. You probably guessed, Vermont State Police. Obviously, we're a heavy consumer of towing practices, so we have a a vested interest in this. We appreciate all the input that we're hearing today, and obviously some big topics to cover. So appreciate everyone being here and participating today.
Okay, thank you. So I'm going to invite anybody who has not already had an opportunity to speak to raise their hand, and now is a good time to share your views. We set aside 2 hours for this public hearing, but I appreciate that folks have kept their remarks high level and brief, with an expectation that more details and a more thorough analysis of various perspectives and positions can be submitted in writing.
You just froze on us, Chris.
Sometimes attorneys have to stop and think for a minute.
I've never seen him at a loss for words.
The question is, do we let him back in?
Sorry for that brief interruption, folks. I need to check to make sure the recording function is still happening. It looks like it is. And we were just about the point where I was going to suggest that if there are no other public comments, we can simply adjourn. On the other hand, if anybody has anything left to add, feel free to do so now. I am not seeing any hands. So with that, I'm going to stop the recording and we can conclude the public hearing for today.